Reginald Rye. You said 4. It was 4, right? 4 Midlands that I signed. Oh, that's some guy. Oh, really? Are you Reginald Frederick Rye?
Yes, ma'am.
I have 2 cases here for Mr. Rye. I have 23T00696FY and 23T00760FY, people of the state of Michigan versus Reginald Frederick Rye. Attorney Rush.
Yes, Your Honor. Kevin Rush on behalf of Mr. Rye. I had gone through the trial rights this morning, including the rights to a preliminary examination, and then Mr. Szabo interviewed Mr. Rye. It's my understanding he's indicated he understands both and is waiving any further reading. Indicated that he is not employed at this time, so he is requesting court-appointed counsel.
All right, thank you, Mr. Rye. Your attorney stated that he did go over your charges, the maximum possible penalties for those charges, as well as all of your rights with you. Do you need me to read any of that to you again?
No, but can I state something about
No,
this, Your Honor?
not yet. Not yet. Hold on. Hold on.
Mr. Rye, I need to get through what I need to get through, and then if you have any questions, I will allow you to ask a question about today's proceedings, but I'm sure your attorney has already advised you that you have the right to remain silent, and you should utilize that right. Nothing you say to me today in regards to the facts of the case or the alleged facts of the case is going to do you any good and could get you into further trouble. All right, so back to what I was asking. Your attorney stated that he went over the charges, the maximum possible penalties for those charges, and all of your rights with you, and you stated you do not need me to read those to you again. Is that correct?
Yes, ma'am.
You know and you understand all of those things?
Yes, ma'am.
I waive the reading of the charges, the maximum possible penalties for those charges, as well as Mr. Rye's rights, as both he and his attorney have indicated he knows and he understands those things, and he does not need me to read them to him again today. We'll enter a not guilty plea on his behalf on both of these 2 cases and set the matters for probable cause conference as well as preliminary examinations. I will appoint court-appointed counsel on both. Attorney Rush, before you speak on bond, I will let you know that I just signed 4 new felony warrants for Mr. Rye that we will be hearing tomorrow morning. So go ahead.
Okay. Well, he's indicated, my understanding is that the address is correct. I think that's the Elmwood Drive address. He resides with his girlfriend. As I indicated, he's not employed. He is on probation. It looks like it's a felon in possession case, but he's indicated he's kept all of his court dates. There is a bit of a question mark on this. It was something that he had alluded to, and I had a chance to look it up. This home invasion case in the first degree with the domestic violence, it's from December 30th, 2022. He has an identical case, and I'm looking at it right now in Judge Manley's courtroom, and those are charged actually same incident date. It is December 30th, and those charges are domestic violence and a breaking and entering without owner's permission misdemeanor, and that is set for a pretrial on the 5th of April. So it does somewhat appear that this is the exact same case that is now resulting in perhaps an increase up to the home invasion. I don't know if, one is one jurisdiction and one is the other, but it does appear he's already been charged with similar counts arising out of the exact same incident. The other case is a taking of a PlayStation. I won't get into that necessarily, but I'd ask the court to take that into consideration, that it does look like he has been charged and been in the county jail. It's $1,000. It looks like a 10% bond that were not posted on those 2 misdemeanors. That appears to be, I don't know whether it's a double jeopardy, makes it interesting anyway. or not, but there is a pending case arising out of this exact same incident. I just asked the court to grant him a reasonable bond, perhaps even with tether on both the cases. He knows he can have no contact, but he has not posted bond on the other 2 misdemeanors.
All right, thank you. Well, I will say, Attorney Rush, that if that is the case, that these 2 cases are, the case that's in front of Judge Manley and the case that we're dealing with today are exactly the same incident, I would agree with you that one of them should be dismissed because of double jeopardy. However, there is a chance that Mr. Rye is being charged for 2 incidents on the same day with the same person, considering how many cases he has. So it could be that he's got more than 1 case from the same day. So we will let he and his court-appointed attorney figure that out. I'm certainly not going to dismiss the case today. And Mr. Rye is not going anywhere today because he has 4 new felony cases that he needs to be arraigned on tomorrow. And good Lord, that's all I've got to say is good Lord. I am going to issue, let's start with the 0696 case. That's the larceny in a building case. I am going to issue a $20,000 10% bond on this case. And while Mr. Rye,
That's $100 is not a felony.
Stop.
you cannot say anything, Mr. Rye, in regards to that. You're being charged with what you're being charged with. If you have a problem with it, you can talk to your court-appointed attorney about it. The paperwork looks just fine to me. While you are on bond, if you are released, which I don't think is going to happen, but if it does, you are to be placed on GPS tether, of course. And you are not to use any alcohol, any recreational marijuana, or illegal controlled substances. You are not to possess or purchase any firearms or any other dangerous weapons or ammunition, and you are to check in with our pretrial services department. In regards to the 0760 case, there are 2 counts here. I note that one is a felony and one is a misdemeanor. So in regards to the felony count, I'm going to issue a $50,000 cash surety bond as to count 1 and a $10,000 cash surety bond as to count 2. I will note that Mr. Rye has gotten up and left, but I am going to continue here. And the same terms as the other case in regards to GPS tether, no alcohol, recreational marijuana, legal controlled substances, no firearms or any other dangerous weapons or ammunition, and pretrial services. Obviously, if Mr. Rye is released on these cases, he doesn't have to have 2 tethers put on, the same tether for both, but I want to make sure that it's indicated that it's required for both cases. Next court dates will be probable cause conference on April 13th, 2023 at 1:00 p.m. Preliminary examination date for both cases on April 19th, 2023. Those are both in front of Judge McCabe. Circuit Court Judge is Judge Bell. Anything else, Attorney Rush?
I apologize for the behavior, Your Honor.
That's all right. You are Reginald Frederick Rye, correct?
Yep.
Mr. Rye, I want to let you know before I begin your 4 cases this morning. Yesterday you were arraigned as well, and you got up and left the room. I want you to know that if you decide to do that again today, I'm just going to continue on with your hearings. All right, let's see. I have case number 23T00765FY, 23T00766FY, 23T00767FY, 23T00768FY. All are the people of the state of Michigan versus Reginald Frederick Rye. Attorney Zabel.
Yes, Your Honor. Neil Zabel appearing on behalf of Mr. Rye. Your Honor, I went over his felony rights with him. He told me he understood those rights, including his right to a preliminary examination within 21 days, and would waive the reading of those rights. Also went over all of his felony complaints with him, including all the charges and maximum possible penalties. Mr. Rye disagrees with most of the charges and charges anyways, but he does indicate to me he understands them and he would waive the reading. I do want to point out.
I want to hear all that again. I would like to hear all that again.
All right. Mr. Rye, what part do you want to hear again? Do you want me to read your charges
All
again,
my
the penalties again, your rights? Wait until I'm finished. The charges again, the penalties again, your rights again, or all of it?
All of it.
All right. Let me start with your rights. Mr. Rye, you have the right to remain silent. Anything that you say orally or in writing can be used against you in court. You have the right to have a lawyer present during any questioning consented to and today. And in fact, you do have a lawyer here with you today, Attorney Szabo. If you do not have the funds to hire an attorney, we will appoint you one, and that is what I am going to do today. You have a right to a lawyer at all future court proceedings, including this one. You also have a right for a probable cause conference to be set not less than 7 days or more than 14 days after the date of this arraignment, and a preliminary examination set not less than 5 days or more than 7 days after the date of the probable cause conference. You have the right for me to determine the form of your bond today, which we will talk about in a few minutes. Do you understand your rights as I have read them to you?
Yes.
All right. Now, in regards to the charges and the maximum possible penalties, I have the 23T00765FY case states that Reginald Frederick Rye, count 1 is home invasion in the first degree, did break and enter or did enter without permission a dwelling located at 615 Berry Avenue with the intent to commit an assault therein, and while entering, present in, or exiting the dwelling was armed with a pistol, a dangerous weapon, and Nancy Harrison and or Matthew Harrison were lawfully present therein, contrary to MCL 750.110A2. That is a felony punishable by up to 20 years and or a $5,000 fine. A consecutive sentence may be imposed for any other conviction arising out of the same transaction. Count 2 is felony firearm weapons charge, that Reginald Frederick Rye did carry or have in his possession a firearm, to wit a pistol, at the time he committed or attempted to commit a felony, to wit home invasion first degree, contrary to MCL 750.227B. That is a felony punishable by up to 2 years consecutively and proceeding any term of imprisonment imposed by the felony or attempted felony conviction. Mandatory forfeiture of the weapon or device. Count 3 is assault with a dangerous weapon or felonious assault. That the defendant did make an assault upon Michael Harrison with a dangerous weapon, to wit a pistol, but without intending to commit the crime of murder or to inflict great bodily harm less than the crime of murder, contrary to MCL 750.82. That is a felony punishable by up to 4 years and or a $2,000 fine. DNA to be taken upon arrest. A consecutive sentence may be imposed under MCL 750.506A if the assault was committed in a place of confinement. Count 4 is a felony firearm weapons charge as well, that the defendant did carry or have in his possession a firearm, to wit a pistol, at the time he committed or attempted to commit a felony, to wit felonious assault, contrary to MCL 750.227B. That is a felony punishable by up to 2 years consecutively with and preceding any term of imprisonment imposed for the felony or attempted felony conviction. Mandatory forfeiture of the weapon or device. I'm not asking if you agree with them, but do you understand what I have just read to you?
What I don't understand is I can get charged 4 times for the same gun that I allegedly had.
You can get charged for the charges I just read to you. Yes. You understand what I have read to you?
Yeah, I guess so.
All right, next case is 23T00766FY. This felony complaint states that Reginald Frederick Rye First count is assault with a dangerous weapon or felonious assault that Reginald Frederick Rye did make an assault upon Michael Brabs with a dangerous weapon, to wit a pistol, but without intending to commit the crime of murder or to inflict great bodily harm less than the crime of murder, contrary to MCL 750.82, which is a felony punishable by up to 4 years and or $2,000. DNA to be taken upon arrest. A consecutive sentence may be imposed under MCL 750.506A if the assault was committed in a place of confinement. Count 2 is weapons felony firearm. Reginald Frederick Rye did carry or have in his possession a firearm, to wit a pistol, at the time he committed or attempted to commit a felony, to wit felonious assault, contrary to MCL 750.227B. That is a felony punishable by up to 2 years consecutively and preceding any term of imprisonment imposed for the felony or attempted felony conviction. Mandatory forfeiture of the weapon or device. Do you understand what I have just read to you there, Mr. Rye?
Yes.
Next case is 23T00767FY. States that Reginald Frederick Rye, and you know what? I apologize. The 765 case, the date is on or about February 6th of 2023. The 766 case is on or about February 6th of 2023. This 767 case is on or about February 6th of 2023. This case states that Reginald Frederick Rye, count 1 is armed robbery, did in the course of committing a larceny of a wallet and money, assault or put in fear of a person present when Casalo Santiesteban, and in the course of that conduct possessed a pistol, a dangerous weapon, contrary to MCL 750.529. That is a felony punishable by up to life in prison and or any term of years. Count 2 is weapons felony firearm that Reginald Frederick Rye did carry or have in his possession a firearm, to wit a pistol, at the time he committed or attempted to commit a felony, to wit armed robbery, contrary to MCL 750.227B. That is a felony punishable by up to 2 years consecutively and preceding any term of imprisonment imposed for the felony or attempted felony conviction. Mandatory forfeiture of the weapon or device. Do you understand those charges, Mr. Rye?
Yeah, I guess. But I got a question. How am I doing all this February 6th when I was incarcerated and didn't get out till February 6th? That's what I want to know.
Well, you're gonna have to talk about that with your attorney.
I guess that's for trial. So I mean, it's all right. Go ahead on the next one, please.
All right, thank you. 23T00768FY states February 18th, 2023. Reginald Frederick Rye, count 1, controlled substances, possession of cocaine, heroin, or another narcotic less than 25 grams. Did knowingly or intentionally possess less than 25 grams of a mixture containing the controlled substance fentanyl, contrary to MCL 333.74032A5. That is a felony punishable by up to 4 years and or a $25,000 fine. Count 2 is malicious destruction of personal property, less than $200. That is a misdemeanor charge. That states that Reginald Frederick Rye did willfully and maliciously destroy or injure a truck window, the personal property of Michael, Cleary, and the amount of the destruction or injury was less than $200, contrary to MCL 750.377A1D. That is a misdemeanor charge punishable by up to 93 days and or $500 fines or 3 times the amount of destruction or injury, whichever is greater. Mr. Rye, do you understand that?
Yes, and I have a right to a speedy trial, right? Can I go ahead and request I want a speedy trial on all these? I want that on record,
yes,
please.
Mr. Rye. There you go. It is on the record, Mr. Rye. All right, Attorney Szabo, then. I have read, Mr. Rye, all of the charges and maximum possible penalties for those charges, as well as all of his rights, and I know that you did that as well. At this point, I will appoint court-appointed counsel on all of these cases, as I did yesterday as well, and I remember that request being made. We will set this matter, or all 4 of these matters, for probable cause conference as well as preliminary examination. And Attorney Szabo, what would you like to say in regards to bond?
Well, Your Honor, I did take bond information from Mr. Rye yesterday. Today he walked out a little bit early. I don't think it was intentional. I think he was just a little upset. Told me he lives at the address listed. He's lived in Genesee County for 5 years. He's on probation for felon in possession of a firearm, and I also believe felon in possession of ammunition. And I'd ask, I realized I spoke with Mr. Rush yesterday, and the court gave substantial bonds to Mr. Rye yesterday. I'd ask for a reasonable bond on each case. Thank you.
Yesterday wasn't reasonable for sure.
Today is going to be reasonable as well. And let's see, I have 4 cases to go through though here, so bear with me. Let's see, on the 765 case, there are 1, 2, 3, 4 charges here. There is going to be a $25,000, 10% on each count. By my calculations, that comes to $100,000, 10% bond on this case. If Mr. Rye is released, he is to be placed on GPS tether. He is to report to pretrial services. He is to be randomly screened for drugs and alcohol. He is to attend outpatient services at New Pass or Odyssey House. Obviously, no alcohol, recreational marijuana, or illegal controlled substances, no firearms or any other dangerous weapons or ammunition, and no contact whatsoever with the alleged victim in the case.
Excuse me, Your
Right,
Honor.
on the
I can't just recommend health treatment or something like that, because that's what I really need.
Mr. Rye, Mr. Rye, you are done. You're done speaking today, Mr. Rye. No, you cannot. Let's see, 766, assault with a deadly weapon and weapons charge. There's 2 charges here. I'm going to also set a $25,000, 10% for each count here. Same provisions as the 765 case in regards to tether, pretrial services, random drug screens, outpatient substance abuse services, no contact with the victim, no alcohol, recreational marijuana, or illegal controlled substances, and no firearms.
Never had one.
23T00765.
So what's my bond amount? 100,000 on each.
Why? 50,000, 10% on this case. Next case, 23T00767FY. This, Attorney Zabel, this is armed robbery case. Under Rule 6.106, I am permitted to not give a bond at all and not allow pretrial release if a defendant is charged with armed robbery, and unless I find by clear and convincing evidence that the defendant is not likely to flee or does not present a danger to any other person. I find that Mr. Rye most definitely presents a significant danger to many other people and to our community in general, and so I am going to deny bond on this case.
Why? Because of hearsay complaints? Where's the evidence? What evidence?
Next case is 23T00768FY. This is the controlled substances and malicious destruction of property. That will be a $10,000, 10% bond for the controlled substances charge, and then a $5,000, 10% for the count 2, the misdemeanor charge. And then the bond provisions on that case would be the same as the 23T00765FY case. All right, next court dates for these matters will be, they are all the same date. It is April 13th, 2023 at 1:00 p.m. for a probable cause conference. Preliminary examination date is set for April 19th, 2023. They are all in front of Judge McCabe, and I do not have the circuit court judge yet for today.
I'm entitled to one within 7 days, not 11. I'm entitled to one within 7 days, not 11.
You're all done today. Jail, will you remove Mr. Rye from the booth, please?
I got on record. 7 days, not 11. It's my right.
7 to 14.
And I need you to
Definitely.
that is 100,000 things right now.
Okay, all right, and Jail and Attorney Zabel, just give us a moment because Gail's got a lot of things that she's got to write down for those 4 cases.
Sure.
I have to write it.